What's up, Colorado Realtors? I'm Scott Peterson. Thank you for joining me for another edition of Legal Bites. We're back at it again with the Commission Position Statement Series. I know these are everything you hope for and wish for, delivered daily almost as frequently as I could into your inboxes and onto your YouTube screens. But I'm only one man, so be patient. But we're going to get through all of these. And we had an interlude just before. I inserted another one on an important specific issue related to tenant security deposits. So we interrupted the series for a brief moment, but now we're back at it. Commission Position Statement number 9 is what we're up to now. And this is working with FSBO sellers, FSBO owners is what Commission Position Statement number 9 addresses. And I want to kind of walk you through some things. It's a good commission position statement, and it addresses issues that come up in the real world quite a bit for some of you guys. And may increasingly so as we have the potential of seeing maybe more FSBO sellers out there, kind of depending on market conditions and everything. So what CP9 starts off talking about is if you're representing a buyer, so you're working with a buyer already as an agent or as a TB, and they become interested in some FSBO property or some potential FSBO property, seller who's unrepresented, obviously. In that case, what they describe, the commissioners describe in the position statement you ought to be doing is before you show that property, you need to be having a good open conversation with your buyer about the implications of a FSBO property, viewing a FSBO listing. And that's going to be a conversation about brokerage relationships as well. If you're an agent for that buyer already, you might want to refer to your exclusive right to buy and see if you have the ability to change status, if that might become something that is appropriate, and become a transaction broker for the buyer and a TB for the seller as well. Maybe you're going to stay, as I think is probably a great idea, to stay an agent for the buyer and then to treat the seller, FSBO seller, as a customer. But having that conversation and understanding the brokerage relationship piece with your buyer before showing that property is important because you're going to have at a very early stage, a conversation with the seller about what your brokerage situation is. So it's best to know with your buyer where you're going to end up there. You want to talk about compensation as well. There is, that's uncertain. If your buyer has committed to compensating you through your exclusive right to buy, then they need to be made aware of the fact that might be the case because there's a chance that the seller won't be, or there's going to have to be some additional discussion related to compensation. And that should be a discussion you have with your buyer to begin with, to help understand, for everybody to understand the potential implications there, depending on what they may be. And then the other possibility is you're gonna talk to the seller about, or if the buyer says, hey, I'm willing to change status if they've already agreed to allow you to change status, and you can talk to the seller at that point, and you're either going to give the seller a broker disclosure to seller, that FSBO for sale by owner in the parentheses is broker disclosure to seller, disclosing your relationship with the buyer as presumably an agent. You're going to treat the seller as a customer. But if you're going to enter into a brokerage relationship with the seller, remember, for a seller, you have to have an exclusive right agreement. All right? And so in that case, what might be appropriate, what probably would be appropriate, is what would be a single party listing agreement. So you're going to prepare an exclusive right to sell with that seller, establishing a transaction brokerage relationship, presumably, with the seller, and it's going to be just for a single party, for your one specific buyer. So you're going to make it a single party listing agreement. And then you could treat the seller as a TB, treat the buyer as a TB, change your status with them if you were an agent, or remain a TB for them, and you're in business in that case. The other thing, before I get to this next slide, that I want to point out is issues with writing a contract in a FSBO situation. And reviewing a contract in a FSBO situation. So I'll bounce back here a little bit to this slide. This becomes a bit more of a problem because if you're going to treat the seller as a customer, you're representing the buyer, you're going to be writing an offer probably for your buyer and giving that to the seller, and you're constrained to a large degree, a very large degree, since they're a customer and you don't have a brokerage relationship with them, with regard to how much, input and feedback and any brokerage services you can't really provide to them. You can provide what would be referred to as ministerial services, very cursory kind of surface explanation about maybe dates and deadlines and some of the contingencies and things of that nature. But it does put you in a bit of an odd position, and that's the situation where you're going to be the agent for the buyer and treating the seller as a customer, if that's where you end up. You got to be cautious in that one little area. The other thing that might come up in this FSBO world is you're going to hold an open house for a FSBO seller. So maybe you've got some friend, neighbor who's not listing the property, they're selling the property on their own, and they say, I'd like for you to maybe sit some houses. And you're thinking, well, maybe I'll find pick up some buyers, maybe I'll, that's what I like doing on my weekends, whatever the reason might be. You actually are allowed to do that. But a couple of things need to be considered if you're going to be sitting an open house for a FSBO seller. One is, what's the brokerage relationship? You could still treat that seller as a customer if you're sitting the open house, and that's the second part of this slide. First part is, let's say you're going to establish a short-term listing agreement. You might do a 24 or 48-hour listing agreement with that seller that is exclusively for the purposes of that open house and any buyers that may come through during that open house, that very limited, narrow, focused period of marketing. And that would be appropriate if that's what you guys agree to. And in that case, you're going to want to make sure you're talking to the seller and emphasizing in that short-term listing agreement the compensation, any compensation that may be applicable in the exclusive right to sell listing agreement that the seller may be obligated to pay. And also make sure you're focused on that holdover period, because you want to probably, in order to protect yourself, you're going to want to have some holdover period where if during that open house these submitted prospects or buyers come along where you would be representing the seller on that limited basis. Remember, you've only got like a 24, 48-hour listing agreement. You're going to want to make sure you're contemplating a holdover period so that you could actually service the business beyond that. So that would be one way that you could sit in an open house. The other possibility would be that you're going to give that seller, again, another broker disclosure, essentially letting them know, hey, you're a customer. I don't have any brokerage relationship with you. I don't have any obligations to you. I'm just going to set your open house. And if I find buyers for my own, that's great. Otherwise, I'm going to set your open house. If you do that, you're free to do that. But it is important that you are disclosing to anybody and everybody that you do not represent the seller. Okay? So if you've got buyers that are coming in and floating through this physical house, you've got to be very clear with them that you are not a representative for the seller. And to the extent that you're engaging with buyers, you would then be giving a broker disclosure to buyer that you would be their transaction broker in a scenario like that. And then if you're doing any advertising on a FSBO listing, which again you can do pursuant to Rule 6.10.f.2 is where this comes up. If you're going to advertise a FSBO listing, you can do that, but there's some limitations on it, unlike a normal listing where you have an exclusive right agreement. If you're going to advertise a FSBO listing, you need to do it with written permission from the seller to advertise that FSBO listing. You need to have clear and conspicuous disclosure on the listing that you don't represent the seller, because you don't. And then obviously you can't list it on the MLS or other information exchanges. Like that doesn't work for MLS rules and for a variety of other reasons. But to the extent that you want to use a FSBO property to advertise, maybe promote, help promote your brokerage business and simultaneously promote this for sale by owner property, you could do it. You just have to adhere to those limitations. So anyhow, that is commission position statement number 9. And we'll be back at some point with commission position statement number 10. So hold your breath, because that's going to be coming soon enough. Hope everybody is getting ready for the end of winter and getting ready to get into spring. And we will see you again on another edition of Legal Bites. Thanks, guys. Bye.